Today in our Ask the Expert segment, we will be examining the area of renting residential property, specifically landlord protection. As with anything, there are correct procedures that you can follow to help keep you out of trouble, and being a residential landlord is no different. To further explore this topic, we ask our local real estate expert, Thompson from the Thompson Law Group in Virginia Beach, about some of the mistakes that landlords often make.
So being a landlord can be a nightmare scenario. It can be a very pleasant scenario, but you have to know the proper steps to take with dealing with residential tenants. Virginia has the Residential Landlord Tenant Act, which has a lot of provisions which are very favorable for the tenant. And you need to be aware of that. So you need to protect your rights as a landlord. Number one, you need to properly vet the tenant. That is an applicant to move into your property. Number two, the proper move-in inspection and move-out inspection documented with pictures. And number three, adhering to and enforcing the provisions of your lease. So number one, you may get a ton of applications, all right? You really need to, my mother used to say an ounce of prevention is worth a pound of cure, if you will. So you have a right as a landlord to require a credit check. So you can run the credit of an applicant, you can do a background check, and you can also follow up with references. So if there are any prior landlords, you want to talk to those prior landlords to see what kind of a tenant they were. Look at the credit score, see if they have a bad score or a high score. See if there's a lot of judgments on their credit from different creditors. If there's a judgment from creditors or if there's an eviction or whatnot, huge red flag for you as a residential tenant, as a residential landlord. Number two, the walk-in inspection. So the move-in inspection. The tenant has to provide you at the end of the term of the lease, they have to turn over the property in the same condition substantially as it was in when they moved in, absent normal wear and tear. Now, in order to establish what the condition of the property is, you need to do a move-in inspection and you need to document the condition of the property via pictures or video. That way, if it's in different condition when they move out and there are damages, you can compare the move-in video and pictures with the move-out video and pictures in order to establish your damages if you needed to go to court. Number three, all of the language in the lease is there for a reason, all right? It has legal implications. So both you and the tenant need to comply with the language on the lease. So for example, if it's got a due on the first clause for the rent and it's late after the fifth, you need to send out the notice as a landlord. You need to be proactive. Send out the notice that the rent is late. We have what we call in Virginia a 5-day pay or quit notice. You don't want to risk what we call a waiver, okay? So if you are looking the other way and you're not enforcing the lease, you could as a landlord be vulnerable to waiving a provision in the lease which you didn't even know that was in there to begin with. So enforce the provisions of the lease, do your walk-in and walk-out inspection with pictures, and make sure that you vet with due diligence your tenants who are applicants.
Thanks, Brett. For those that want to learn more, they can connect with Brett Thompson and the Thompson Law Group in Virginia Beach at tlgva.com or call them at 757-486-3333.